My name is Goldman, and I'm an attorney with Goldman and Associates. And today I'd like to discuss something that's a very popular issue when clients call up about a custody matter or a divorce or really anything that the firm does. And the common question we always get is, how much does it cost? Well, it's a good question. You got to remember, folks, though, that when you deal with legal services, you're not buying a bag of apples. It's not like going into Best Buy and saying, okay, there's a 55-inch TV, how much does it cost? It's not an item. It's a service, and the service is usually based on a retainer against an hourly rate. Let me discuss a little bit about that first. Any project requires that a budget be in place. Now that budget is what law firms call a deposit or a retainer. It's really just an amount of money up front to begin your case, earmarked toward your case. And how much that retainer is going to be directly related to what the project is. So like any other project, if you're building a building, are you building a 3-story building or a 10-story building? There's no question that if you're building a 10-story building, the amount of deposit that you're going to have to put up is going to be greater than the 3-story building. So it's the same with any kind of litigation. If you have, for example, a divorce where it's completely non-contested and there's no children and there's no property to divide and it's a 18-month marriage, that deposit or retainer that's necessary for that project is going to be way, way less than a marriage of 18 years where there's a custody dispute regarding children and the parties own a golf course and there's multiple businesses or there's tax liability or liens. Clearly, that's a completely different kind of project. So when you look at the retainer, you're going to have to, the attorney's going to analyze what's the project, what's the scope of this project, and that will determine how much money the firm requires be put aside or earmarked toward that file. Now that money is not a flat fee item. It is strictly a time-based item, meaning that the retainer will be exhausted at a rate based on the firm's general hourly rate. Now here at Goldman and Associates, I will tell you that over the years, as we've developed expertise and experience, that our hourly rates have changed. I think you're going to find that most law firms that are preeminent in the field have a higher rate than lawyers might charge who are perhaps newly schooled or newly admitted to the bar. Here at Goldman and Associates, the general hourly rate is $3.25. And that rate, for that rate, what a person gets is not the wherewithal of one attorney. A person gets the full benefit and the full thrust of all the staff at the firm, all of the firm's combination of paralegals and attorneys and legal assistants, all who work together on your case to make sure that you get the desired result. That whole machinery of that firm you get for that hourly rate. So it's not just a question of, well, I got a lawyer and he charges X. You're employing a legal team. And while that rate may be different than a rate another firm may charge, you need to understand what you're getting. If you look at that product, you're getting the whole force of the firm's legal machinery, and that has a definite value. And in the long run, it ends up saving you money than, for example, if you hire a solo practitioner and he's charging $275 an hour. Because what you may not realize is, number one, if that guy's in court and you call, you're not getting him. You're getting a voicemail. So now there's a whole back and forth. And then he calls you and he can't get you. And then you're going back and forth with the phone tag and you're being charged for all of that, all those efforts that he may make to reach you. Whereas in a law firm, if you call somebody and they're not in court, there's always a second attorney available who's knowledgeable about your case that you can talk to. There's always a staff member available to you. Not only that, if things have to be scanned into the file or Xerox, if you're with a solo practitioner, you're being charged his hourly rate to do that. Whereas in a law firm environment, there is a different rate for paralegals or legal assistants. It's a fraction of my hourly rate. So ultimately, it ends up saving you money. Not to mention the experience and expertise moves things along quicker. Attorneys in that situation are better able to move things down the court's system much quicker than otherwise. So ultimately, it saves you money. What you get when you hire us is you get that level of experience, that level of expertise, and frankly, in the long run, when you're dealing with that situation, it saves you a lot of time, and therefore it saves you a lot of money. The factors that go into a case once you determine your retainer and your hourly rate is how many hours are going to be put forth into the case to get it resolved. See, that's where the experience and the expertise comes into play. Generally speaking, another factor that comes into play when you talk about the length of a case is the level of pushback you got from the other side. When you have a case where both sides are in lockstep on what they want to do, and the attorney is basically there to tweak the details, that is a much quicker, much more cost-effective case when you got people fighting over pots and pans. And I got to tell you, sometimes they don't know that they're at odds. I've had couples come in here saying, we've got it all worked out. We just need your assistance on getting us through this process, but on the substance, we've got it worked out. And then I'll start asking them questions about assets, about liabilities, about debt distribution, about tax liability. And all of a sudden, a fight breaks out right in front of me. So much for the consent judgment, as these parties are clearly at odds and cannot be represented by one attorney and are going to have a battle on their hands that they didn't even realize. And why? Because they didn't know what the issues were. And they didn't know that they presumed that they were in agreement on how the kids were going to be handled. They didn't realize that the other one wants to run the point on the custody of the children. That's just an example. So the point is, the longer a battle you have, the more costly it is. And whether or not you have a long battle has a lot to do with the level of pushback from the other side. Again, if the parties are in agreement, that's quick. If the parties are at odds, like most are, that becomes a longer piece of litigation. Obviously, if you have questions about this, you need help navigating this system, reach out to an expert, give us a call. We'll be glad to help you out.